Welcome back to Courtroom Authority, where legal drama meets real-world consequences. Right from the start, we've got Hampton's Apartments facing off against tenant Jasmine Weatherby. Her attorney argues she's been paying, but the landlord insists otherwise. And get this, it all kicks off over just a $15 late fee mistake. But don't let that fool you. This case snowballs into a heated battle over unpaid rent, 7-day notices, and whether the court even followed the right rules. Who's in the wrong here? The landlord demanding strict payment or the tenant caught in a paperwork nightmare? Let's dive in, because the tension only escalates from here.
This is Hamptons versus Jasmine Weatherby, 2502045LT. Mr. Smith?
Good morning, Your Honor. Andrew Smith, P64541, appearing on behalf of Hamptons.
Mr. Sandweiss?
Good morning, Your Honor. May it please this honorable court, Stuart Sandweiss, appearing on behalf of the defendant, Jasmine Weatherby.
Okay, and is the manager here? There seems to be a dispute as to what was paid, and I asked that the manager from Hamptons be present.
I did talk with her this morning. We did get a call from your court, and there was a $15 discrepancy on one late fee where we were $15 over.
Yeah, I get it. That's fine. I understand. We all make mistakes. But it's still, they're claiming they paid everything, it looks like. Right, Mr.
No, Judge, here's the situation. There's a couple things. Number one,
I want to slow down.
Oh, I'm sorry.
You are contending that this was paid, right?
No.
Paid for which month?
Well, I paid in full up until today, up until the day of the judgment.
No.
They have not paid, Your Honor. That's not
what I'm contending at all.
They're not paid in full. They have not paid. They're contending the value, the legitimacy of the default on the dates.
I'm Judge here. If I may, can I? If the court will allow me to explain, I'll tell you exactly what I'm telling you.
Okay.
So there's issue substantively and there's issue procedurally. Substantively, they filed a complaint that says that rent was paid through March 31st. So obviously that means that they're suing her for 1 month's rent was April. She paid April because I attached the receipt. She gave me the receipt. I popped it into the it's on page 2 of the motion, and it shows that it was paid on April the 8th. So they gave her a 7-day notice on April 7th. She paid on April the 8th. Okay. Does she owe May? She probably does.
Probably.
But that's not what we're here about, because they didn't give her a 7-day notice for May. They said she's paid. They said she owes for April. So that's problem number one. Problem number two is that
when was the judgment entered, Mr. Smith?
Give me 1 second. I'll give that.
June the 2nd, Judge.
Pardon?
June the 2nd.
June 4th.
So your position,
I'm sorry,
that's
June
why
4th.
I guess
June 4th.
your position is that she paid the amount that was due in April, and that therefore what? They should have dismissed?
They sued her for April rent. She paid April rent.
I get it.
They don't have a 7-day notice for May, and they didn't file a complaint for May. If they want to file a brand new complaint for May and June, great, do it. But there was also an issue of notice, because they undisputedly they only gave 6 days notice. She said she didn't get it at all. According to them, according to what's on file with the court, it was only done 6 days before the hearing, and the court rule says 7 days before a hearing.
Your Honor, just to point out, he says we didn't give her notice, but then on the other side of the argument says, well, in case you did, it was only given 6 days, which defeats the whole argument to begin with. And then the proof of service itself, we attached the actual filing with the post office, and there was a second service by the court, both for May being a separate month, May being why we're here, them admitting that probably they haven't paid May. They haven't paid anything.
Okay.
Then here today arguing motion for reconsideration on a default for non-payment. And his argument is that it was a day too soon, which isn't true. The facts speak for itself.
Judge, if I may, because I didn't interrupt him. I said they filed a complaint saying it was owed for April. That's what we're here on. That's all this. They never filed a complaint for May. They've never filed a complaint for June. They've never given her a 7-day notice for those.
They don't have to.
Why don't they have to?
They do not have to do that. It depends on when the judgment was entered, and you just said June, right?
The judgment was entered on June the 4th.
Okay, June, right. So
Okay.
what are you suggesting? Are you saying that after she paid, listen to me, you want to talk? Are you saying that after she paid the April's rent, that the balance was zero and
Correct.
that they should have dismissed this case and had to refile another 7-day notice? Is that what you're saying?
No, not exactly. What I'm saying, if you listen to me, what I'm saying is that they never should have filed this case because they filed this case saying that April rent was due. She paid April rent. The only 7-day notice was an April that she received was an April 7-day notice. So you can't file a complaint for non-payment if you don't give a 7-day notice. Where's the 7-day notice for May?
Mr. Smith, did your client receive payment for April's rent before you filed the complaint? Yes or no?
Before we filed, no.
She's got a receipt for April the 8th.
Your Honor, I don't want to interrupt you. Please, I'm sorry. I just want to point out, I think what he's saying is they admit they owe May, but they never got a 7-day in May. But we attached the 7-day to our response. We attached the post office date showing it was 7 days before the hearing. And we attached register of deeds at the court did a second mailing with the 7-day of the notice to the court. So I'm confused by this. I guess what it comes down to is he's really, I guess, arguing a motion to set aside default, which is good cause, which I'm assuming he's saying they didn't get started, which we attached proof they did.
I know, but let me just weed through this on my own here.
Sorry, Your Honor.
You're saying in paragraph 7, Mr. Sandweiss, plaintiff filed this lawsuit claiming that rent was paid through March 31, along with a 7-day notice dated May the 6th of 25, claiming that 1140 was due. If you guys can give me the dates.
Yeah, I'm happy to, Your Honor.
Sort this out. When was the first 7-day notice sent? When was the first 7-day notice sent? When was the complaint filed? Give me those, Mr. Smith.
I got to look the exact dates up. The complaint's filed in March for the April. I don't want to be wrong, Your Honor. Give me a second. I apologize. If I could just say one thing that might help.
Oh, go ahead, Mr.
Smith.
Smith.
Question, Judge, because he's kept mentioning a reply or response or something to the motion. I have not received any response, so I'm not sure what he's talking about.
Okay, I can't. I'm co-counsel. Your Honor, just want to point.
Let's slow down. I'm going to ask my clerk. Jennifer, when was this complaint filed?
The complaint was filed May 20th. I do show a demand for possession non-payment of rent that was mailed May 6th by Katie Spura.
All right. So if they sent that out on May the 6th and you're almost, I think you acknowledged she didn't pay the May rent, what's the problem?
Well, they didn't sue her for the May rent. They sued her for the April rent. That's what the complaint says.
Originally sued for April. She paid most of April. There was an $85 balance for April. In May, we served a new 7-day because she had the balance and she didn't pay May. Then the court just read the dates. We filed the complaint, had a hearing, got a default.
Where does it say all that in the complaint?
What are you talking about? We filed the complaint for April, the total amount. She didn't pay the total amount in her April. She left the $85 balance. We filed a new 7-day, which was attached and provided the court showing what she owed. Then we filed a complaint, filed the court rule on that 7-day notice. And we had our service and the court service didn't appear, got a default entered. Now you're here and you still haven't paid $1 in rent.
Where does it say all these things that he's telling me now? I'm looking at the complaint. The complaint says rent is paid through March 31st.
It's a detailed response that was served on you in the court.
When was this response filed?
Your Honor, it was filed and we received it on the 20th.
There you go, Mr. Sandweiss.
Let me double check because I do not have any M-file response. I'm double checking it. So the last thing that I have on the MI file was the notice to appear that was sent by the court on the 17th.
Counsel, why wasn't your client here?
They still live there.
Because my client never received it, and she received the judgment and she received the notice to appear the same time. So, and I looked at the dates on the notice. The notice wasn't even proper because the notice was sent from the court 6 days before the hearing, and the court will require 7 days. And I'm saying she says she never got it, and I'm saying even according to what he filed, it only was 6 days. Even if let's assume that he's right and they mailed it. Okay, I don't have to tell anybody what the mail's like these days, but it still says, according to their records, it was only sent 6 days before. That's not sufficient service under the rules.
Just respond,
All
Your
I'm
Honor.
saying is set aside the default, reschedule the hearing. You want to have a hearing? That's fine. Set it for next week. That's fine. We'll deal with it. But
I have to find two things: good cause and a meritorious defense. Where's the meritorious defense? She hasn't paid for May. You agree with that, right?
That's what he says. I don't know if she's paid for May or not, but they didn't sue.
Where is she?
They sued for April. She paid April.
Where is she?
What's that?
Where is she?
She's at work.
Well, you indicated all but, I think, in the beginning here that she didn't pay for May.
Or June.
I said I think that's correct, but I'm not going to swear to that because I can't say for sure. I think that is correct, but they didn't sue for May. They sued for April, and she did pay April. If they want to sue for May, they can. Then they'll let them amend their complaint. That's fine. But they're not entitled to a judgment for something that she didn't have notice of before the time. That's what I'm saying. There's a due process issue here. You can't just he can't just come in and say, well, my complaint says one thing, my 7-day notice says another thing, and I'm asking for judgment for a third thing. That's not the way this works.
Wait a minute. I've been doing landlord tenant cases for 30 years. Don't try to educate me. She had a balance of $85. It went to a hearing. She didn't show up. We sent the judgment out to her.
The judgment was for $2,000, Judge.
She didn't pay the balance that was owing for April. She had $85 that was still due and owing. Then she didn't pay for May. It's not incumbent upon them to drag a affidavit out of your client. Your client should have said, I paid for May. I paid for June. This judgment is void. How much did I say that the late fees exceeded? And I trust that was all accidental. Correct, Mr. Smith?
Yes, it was only the May, and it was $15 too much.
Yeah, I just want to make sure that you always only ask me for $70 a month if that's what the contract says.
Judge, we know that very well, and that was a mistake on our part. We apologize.
That's fine. Mistakes are made. I wanted her here more to talk about this because I thought that he was contesting what the balance was. And the fact is, she still hasn't paid. I'm going to deny your motion for reconsideration and or to set aside the default judgment. I will do this. You're going to do an amended judgment backing out the late fees. You're going to submit it to me. And I'm going to make the writ date July the 3rd. So the writ date will be July the 3rd. That shouldn't include any more rent here, right?
Correct.
So you're just going to back out the $10 or $15, do an amended judgment. Your client has to pay up. And that total amount then will be what, Mr. Smith?
Here, give me seconds, I'll tell you. Trying to find the actual judgment, so I said correctly. I apologize.
I don't have the judgment in this packet here.
I don't have the judgment. I have the amount. I want to make sure it's correct. I don't want to say it wrong, but we will take out the $15 and refile it. My understanding, it was $2,265 for rental charges and $176.54 for court costs. That was $15 too much for May's late fee, which we'll deduct and refile.
So you're going to take it. So it's going to be $161.54 then, right?
Yeah, here, let me just get my
calculator. It should be $24.26.54. That's my.
Give me 10 seconds, and I apologize.
Take your time.
So the number I have is $2,441.54 minus 15 comes to $2,426.54. Yep, correct, Your Honor.
Submitted an amended judgment this morning.
And that judge, your ruling is then she would have to pay it by July 3rd, or they could get a writ.
Correct. Actually, I could easily order out now, to be honest with you, but I'm not going to do that. So I'll give her those extra days to come up with the money. Okay? Thank you.
I don't know.
Thanks.
Judge, could I just ask Mr. Smith, or ask the court to ask Mr. Smith to forward me a copy of whatever he filed so that I have it, because I have not seen it.
And there it is. The judge denies the tenant's motion to reconsider and keeps the default judgment in place. But in a rare show of leniency, he gives Jasmine until July 3rd to come up with the money. That's thousands of dollars in rent, minus a corrected $15 fee error. This case is a perfect reminder of how quickly missed payments, paperwork mistakes, and deadlines can spiral into eviction battles. What do you think? Was the judge too lenient, or was this the right balance of fairness and firmness? Let us know in the comments. And if you found this case as shocking as we did, don't forget to like, share, and subscribe to Courtroom Authority for more intense courtroom breakdowns every week.